Okay, good afternoon, everyone. Welcome to the, I guess, final presentation before Vicky's talk. And Legal Fictions is the title. You've all, I'm sure, read the brochure. I'm Bill Goodell. I'm going to give a brief introduction to our speakers and let them go. Feel free at any time to ask questions or play devil's advocate, however you want to. This is wide open. We want audience participation, and this is a collaborative experience if we can make it that. Okay? So the speakers are, we have Bessie Dashbach, also Emma, yes, with Jones, Glad Jones firm, Jones Swanson, and you've got a brochure that tells you about it, but she's basically a litigation manager for one of the top environmental firms in the state and is been intimately involved in their efforts to secure private remedies for coastal land loss in Louisiana. And then you got Rock Palermo with the firm in Lake Charles, and Rock is he's a legend to me because he did a deposition of this guy Don Briggs, all right, who's an industry showman, all right, and he just it's a textbook case of how to dissect someone in a deposition. I think it's actually on the Jones Law Firm's website where you can read it. But if anyone wants to see every move that a defense lawyer can make in a deposition and every move the cross-examiner can make to undo that move, that's your answer sheet, okay? So feel free to read it. It's a very good read, and it's an example of superlative trial lawyering, okay? It is as good as it gets, I promise you. And last but not least, we have Deanne Penner, who is also with Rock's law firm. And Deanne's a PhD history professor who decided she wanted to go to law school and then decided she wanted to get a master's in environmental law. And here she is. And she's doing it, and she's doing it with the big hitters on big issues. And you're going to hear some heady talk about what some of the fictions that have been created to prevent. I mean, look, the Civil Code, right? I mean, this is Julius Caesar. I don't know. You can get Professor Yiannopoulos to talk about how far back, but you've got your basic negligence statute in Louisiana that says whoever damages another has to pay for it, right? I mean, that's a basic codal principle of Louisiana law, been around since Roman law. And these legal fictions say, not so fast, right? So that's what we're going to talk about today, the policy considerations, the legal maneuverings that are done to get away from finding a obviously liable person to clean up their mess or repair the damage that they caused. Okay, so I'm going to sit down and let Rock walk you through his presentation.
Thanks, Bill. Thanks for the kind words as well. Legal fictions, and I know we have a mixed audience of people that may be law students, some lawyers, some that are neither. So some of this stuff may be elementary to you, but for some of you, maybe it's the first time you visited. So apologize for those that this is something you've already studied. Legal fictions is simply something created by the court to speed the legal process along. Adoption is a fiction. Corporate personhood, the fact that a corporation is a person and can live basically indefinitely. Obviously, that's a fiction. Doctrine of survival, when the husband and wife get killed together so that the estate can pass appropriately, we fictionally say if they die together, which one you'd assume died first. So those are just some fictions. The entitle this thing Legal Fictions and Judicial Traps because it's the judicial traps part that is what we're going to be talking about mostly today, and what my colleague Deanne Penner's law review article, which is coming out in a couple of weeks, I think, in the Loyola Law Review, gives a great example of a judicial trap, or what I say sometimes judges don't do the law good. And that's a nice way of saying that sometimes they miss it. You may have heard in law school we used to say, your A students became law professors, your B students became great practitioners, and C students, well, they may become judges. So to deal with that, we have to try and get them educated. This is a quote, all bad precedents began as justifiable measures. Sometimes judges simply, as a matter of either their own politics or economic view at the time, think that the right thing is to rule a certain way despite what the law says. So all bad precedents begin as justifiable measures. We have a lot of law that gets stuck with us for years before somebody says, wait, we've been looking at this all wrong. And so one of the things that, and we've had that in the course of our history, whether we're talking about segregation and desegregation, or whether environmental policy, we always seem to be 50 to 100 years maybe back than where we should be. So it takes a while. The wheels of justice are extremely slow. But importantly, since we probably have some law students here, we have to write articles and we have to keep pushing, because that's where a lot of judges and a lot of law clerks get what they think is the next best thing in terms of law scholarship. So, and I want to say again, the bad precedents, a lot of times you have judges, and we saw this with canal breaches, we'll talk about a little later, that they feel that the sky will fall if they rule a certain way. That we cannot have, the government can't afford to solve what they broke. We can't put that burden on the taxpayers, or industry will be run out of the state. All those things end up giving us occasionally bad law. So what are we going to talk about today? First, we're going to talk a little bit about just the economics of tort law or accountability. And we'll talk about learned hands formula, and we'll talk just to kind of give you a background as to how economics really plays an important part of our tort law, our accountability. And judges either get that right or wrong, and there's a number of ways of doing it. It all depends on how you do the math. You always hear that, in any kind of economic analysis, you can always play with the numbers and get to a different result. We'll show you how that happens, but we show you when you're honest with the numbers, you should come out with the right result. Yale Law School, as many of you know, almost every class is totally taught based upon economics. Who's in the best economic position to solve an issue? So that works in a lot of ways. They don't teach you law at Yale Law School. They teach you how to think, and they teach you the economics of this. And with the economics, you can pretty much solve everything. So we'll talk a little bit about that. The other thing we'll do is talk about, because a lot of people don't understand, how can you sue the government? When can you sue the government? And when do they have immunity? So we'll talk about the Federal Tort Claims Act and how that's a waiver of sovereign immunity. And we'll talk, importantly, about the discretionary function exception, or DFE. That's code. It's a legal trap for, we're not going to hold X liable because we don't expect them to, we're going to protect them from having a policy analysis that maybe should have protected them from the harm that resulted to the people, but they didn't do it right. So we're going to protect them from it. So we'll use Mr. Go as an example, talk about the immunity issues that are tied to that, and then Deanne's article talked about a DFE process and having a process in place where you can still use the DFE but has some protections for the public. So that's what we're going to talk about today as far as a simple roadmap. Talked before, Judge in this case Judge Richard Posner, suggests that academics help judges dig below the semantic surface to understand the real stakes in the case. And there's no better, probably, illustration of that than the canal breaches litigation, Mr. Go, Katrina, because of the tremendous losses that occurred, not from a community, but if you go down to the person, to all the people that were affected, and see that you can solve this if you do the math right. So the point, again, is if you're a law student, write well and write often, and get it published. So Learn in Hand had what's called the DPL rule, or the Learn in Hand rule. It describes a process for determining whether a legal duty of care has been breached, because that's what we want to find out. Before, we said, back in the old days, how do we determine fault, where it was either trespass, it was careless. We came to the regional man type standard. Later on with technology, we said that's not enough, because accidents don't just happen. They happen for a reason. As technology progressed, we said we've got to be able to account for that. So he said simply, if the burden is less than the probability of the loss, well then you're at fault. You had a duty to do the right thing. If the burden is greater than the probability of the loss, well then you didn't have the duty. So that's the simple formula that you can use in almost every case, but the devil's in the details. This is a simple, graph of the burden of adequate precautions and expected harm, whether that's putting a light that doesn't burn out on a hazard in a navigable water body so that somebody doesn't run into it. It maybe only costs $5 to put a light that doesn't have to be changed every month, versus the cost of a ship running into it or somebody dying if they hit it. So you can do this in about every case. The most celebrated case of the cost-benefit analysis was the Ford Pinto. The Ford Pinto, of course, had a fuel tank designed very close to its rear axle, about 9 inches. It also had some bolts that acted as pretty much instigators of explosion on any rear impact. 3 girls were on the road one day. They forgot that they didn't put the gas cap back on. They doubled back, and when they pulled over to do that, they were hit by a large van. The vehicle exploded. I think 2 died instantly from the explosion. The other one died later. In any event, as you can imagine from that accident, about the last thing, I'll tell you about the van. The van was driven, had this front bumper that looked like it had it wasn't a factory-made bumper, so it looked like it helped instigate this, as well as the poorly designed fuel tank. And in the vehicle was drugs and pills and all beer. So there was enough fault at the accident scene where the last thing somebody was thinking was about the Ford Pinto gas tank. But eventually they did. They got to that gas tank eventually. And so Ford's calculus for this, funny, because you may say, well, Ford may never known before this accident about what could possibly happen. But in this, they were both prosecuted criminally and civilly. And their defense was, guys, look, we did this Learn in Hand almost analysis. We called it a cost-benefit analysis. We knew that for $11 we could prevent this from occurring by modifying the design of the gas tank. But we did the cost, and so we looked at the benefits. We said there was going to be 180 burn deaths, 180 serious burn injuries, 2,100 burned vehicles. And this is Ford. This is what Ford presented. This was their defense. And they did the math, and they said, so the burden was, or the probability of the loss was 49.5 million. The cost, the burden, if you will, was 137 million. So the burden was greater than the probability of the loss. Now, they used $200,000 per death. Actually, in Louisiana, many states are different, but as those of you who know, $200,000 is probably spot on for putting a number on a death. Burns, 67,000. Many of you may use Craigslist to maybe find a roommate or to sell your car, but if you did a Craigslist to say, how many of you are willing to have 70-degree burns over your body, we'll pay you, and you take interviews on that, you may find you have to pay a whole lot of money if you ever get one person to agree to have 70-degree burns or 30-degree burns, or any burn for that matter, over their body. So how you do the math is important, but this was their defense, that the burden was simply greater than the probability of the loss, even though it was $11. Now, I will tell you, Judge Learned Hand's rule is specific to the incident. So they wouldn't look at all the vehicles. They would just say, how much would it cost for this one vehicle in this case? So it's kind of plaintiff friendly, because in a case like theirs, you'd say $11 versus, 2 deaths immediately and one that hung on for a while and severely burned, and that's an easy way of saying, the plaintiff wins. The $11 should have been done. So different ways of doing it. It's important when we get into Deanne's analysis of how society should bear the cost of, or shareholders. If it's a company, stockholders are going to say, look, engineer this thing safe because we don't want to have to deal with litigation that's going to ultimately cost us as stockholders. So you do things right. Government, on the other hand, you elect the wrong people and you don't have those that always want to cut the budget and don't put funding into engineering to be able to do the right engineering analysis to keep levees from breaking or flood walls from bursting, then you may have a problem. So and that's the whole DFE. You may say that canal case, Mr. Go case, was because the court got sticker shock. It's going to be too much money for the taxpayers. But in reality, that's what should happen. Somebody has to bear the cost, or else you'll make it where the law that they get a pass. And when that happens, everybody loses. So this is the break-even calculus, just for illustration. And so the cost to replace the fuel tank was $3.96 per vehicle. Then they would equal each other out. In reality, it was $11. So you can see how all depends on how you do the math. 17th Street Canal, flood walls. Interestingly, it's in your materials. I'm not going to spend a lot of time on it, but there was a great ethics study done on both the Ford Pinto case, the Concord, and the 17th Street Canal flood walls as to if we do the BPL, how does it come out on this? And when we look at the actual American Society of Civil Engineers did a study on this, and they said, they did not account for how unstable the soil was and the engineering of it. So Katrina, unfortunately, gave a whole lot of people a way to, especially on the engineering side of the coin, look to see what they were doing and whether they were doing it right. If they were doing the right processes to make sure that people were protected and these kind of things would not happen again. So let's talk quickly about the Federal Tort Claims Act. The Federal Tort Claims Act waives sovereign immunity, and from English days, you couldn't sue the king. The king was immune. So carried over to the government, you can only sue the government when the government says you can sue them. And years ago, they said, okay, you're going to sue, you can sue the government. We're going to set up this process. You can't just sue us, though. You have to do what's called a Federal Form 95, I think it is. It's a 2-page form, looks like a typical government form. You send it to, if it's let's say it's a medical malpractice due to a government healthcare provider, you send it to DHS. They have 90 days or 180 days to settle the claim. If after that time they don't get back to you, then you can sue them. So the important part of that is federal district courts have exclusive jurisdiction over damage suits in the United States involving personal injury or any negligence or wrongful act or omission of any employee of the government, where the U.S., if they were a private person, would be liable to the claimant in accordance with the law. So that brings us to, once you sue the government, what happens next? What's their get-out-of-jail-free card? And Deanne has written a law review article that talks extensively about the ways that can happen and what to do about it. And when you scratch your head and say, how did those judges rule in that case that the government was not liable for what was obvious to everyone, an omission? And the canal breaches case is an excellent case to go through. So, Deanne, take it from here.
Thanks, Rock. I just want to pick up on two things my boss said. The first, if you're a law student and you want to influence judges through your writing, write well, write often, but especially judge your audience. There's a world of difference between law review articles that are written for professors who think a certain way, who are interested in abstract theories, and judges who either state court judges who don't have time, federal court judges who also have very busy dockets. If you want to influence judges, you have to pitch the language differently, the law review article. I'm sure you all have the talent to do that. Second thing I'd like to pick up on, FITCA was passed in 1946. It wasn't a brand new system. It was a replacement. Initially, if you had a private claim against the government, you could go to Congress as an individual, try to get to congressmen to pass a particular act. It was very inefficient. It was very costly. It was arbitrary. If you had the money to do it, if you had the political sway, you might be successful. And it also was very inefficient for the lawmakers who were supposed to be doing more important things. So it was meant to be something that would compensate the victims fairly and something that would alleviate the burden on legislators. The twilight zone of the DFE is one of 13 exceptions that was passed simultaneously with FITCA. It has become the most frequently litigated of the exceptions. It's the largest whole, and by now, at least 74% of the cases brought under FITCA don't even go to trial because of this exception. In fact, the Rehnquist court was particularly hard on the DFE and its conservative activism.
I'm sorry, Dan, I'll get around you. So it's not taking my, tell you what, you hit this button whenever you want to move.
Okay. The Rehnquist court, as you probably all know, was very much against tort actions in general and against equity. And so the DFE was expanded as part of this expansion of sovereign immunity generally. The worst case, and in particular as it impacted the canal breaches case and the peculiar turn that happened with the second appellate panel, was passed in 1991. The United States versus, I'm not sure how it's pronounced, Galbert, which basically said that you don't need to conduct a policy analysis to be protected by this immunity. If there was any possible hypothetical analysis that you could have conducted, that's enough, and you are protected. U.S. versus Gobert was not a public safety case. It was an economic liability case. It affected one man who lost $100 million, and there was no property damage. The circuits, at the time that Duval looked at this case, the time that the Fifth Circuit looked at it, were split whether or not Gobert should apply in these public safety cases. The article that I've written, and it's available online here, and it'll be coming out in February, it looks at two sets of cases. The first is canal breaches, but the other is Barisic, the case against the oil companies right after Katrina. And the basic argument is that it's a dangerous precedent for everyone when you untether liability from a cost-benefit analysis. And we see this in our cases. We take on oil and gas cases all the time. Usually it's oil field contamination. In one interesting case that will illustrate this rule, it's a simple trespass case. A pipeline company decided it would be a safe risk to put an ethylene pipeline under a railroad and a highway because who would find out about it? It's so far buried underground, it's directional drilling and so forth. And so the lawyers told the pipeline company, your maximum exposure is 100,000. So if you amortize this out, it's cheaper not to get permission. So the only way a deterrent can be made is if the damages for that trespass are great enough that then it's folded back into the calculus for the company. As my boss likes to point out, we are responsible for the politicians we elect. But at least we believe that the oil companies shouldn't be let off the hook because not all citizens enjoy the savings that the private stockholders enjoy. I'm sure being from this area, you all know, are very familiar with canal breaches. It was an unusual FITCA case because it actually reached trial. There were at least 15 experts. There were 3,000 exhibits, a very lengthy trial, and a 71-page opinion. And Judge Stanwood Duvall, he found that it was not just that the Army Corps was negligent, it was a cause in fact for the damages, but the negligence was of such a scale that it was monumental, and that this actually consisted of scientific malpractice.
Dan, before you go anymore, let me just, for those, in case we have anyone here that doesn't know about Mr. Go, I want to play just a little bit of video here that will illustrate it as soon as I get this mouse to react to me here.
We are coming to you live tonight from Algiers Point in New Orleans, and I would like to introduce you to my friend, Mr. Go. Mr. Go, which is what everybody calls him here. It's MRGO, Mr. Go, the Mississippi River Gulf Outlet. Mr. Go was hacked through cypress swamps and coastal marshes, hacked through wetlands to connect the Mississippi River and the Gulf of Mexico by a means shorter than nature intended. Building Mr. Go in the 1950s and the 1960s moved more dirt than digging the Panama Canal. Its impact was disaster. Mr. Go, I have come to believe, is trying to kill New Orleans. Mr. Go channels salt water inland, where it's blamed for killing 100 square miles of wetlands. It is a perfectly designed system for channeling the storm surge from a hurricane in the Gulf of Mexico right into the dead center of New Orleans. You can thank Mr. Go for dumping a significant portion of Lake Bourne into St. Bernard Parish during Hurricane Katrina. You can thank Mr. Go for funneling the storm surge all the way up from the Gulf and dumping it into New Orleans East, and then Gentilly, and then the Bywater, and then Tremé, and then the lower Ninth Ward. A federal judge ruled last year that the Army Corps of Engineers is responsible for much of the flooding after Hurricane Katrina because Mr. Go was responsible for much of the flooding.
So that part of it, as you'll hear later, the trial district judge who heard the facts, heard the experts, and many of you got it right. So this was done 5 years after Katrina, this video, and I'm not sure at that point whether it had gone to the appellate courts yet. So anyway, so when you hear that there was a win, you'll hear later that win got taken away, and that's part of the judicial traps we're talking about.
After Hurricane Katrina, and Mr. Go was an Army Corps of Engineers gig. Why did they build Mr. Go in the first place? What was so important that it was worth causing all of that damage, putting New Orleans against all of that risk? What was worth 100 square miles of wetlands and a Hurricane Alley storm surge funnel right into the heart of New Orleans? What was worth it? The year before Katrina, taxpayers spent $13 million dredging Mr. Go, making it even worse. What was worth all that? What does Mr. Go do? What's Mr. Go for? It's for shipping. It's for the shipping industry. And Mr. Go even sucked at that. Before the storm hit, Mr. Go was carrying a grand total of approximately 5 ships per week. That's all. Well, now Mr. Go is closed. It is closed at least to those 5 ships a week it used to get. It has a little dam over the end of it, and they're supposed to get around someday to trying to get back those 100 square miles of wetlands Mr. Go killed, to shut down the Hurricane Alley that Mr. Go aimed right into the heart of the great city of New Orleans. It is too late, of course, but at least, finally, Mr. Go has closed. Mr.
So that's a little bit for those that did not know the history of Mr. Go and what this case was about. A little bit, you heard Rachel Maddow even going through the economics of it in her talk, what it was for, that it served about, at most, about 17 ships. So, anyway, Deanne.
And if I can just, go ahead.
No, you go ahead.
If I just add a little bit to that fact scenario, okay? I mean, knew or should have known, right, is our tort, our negligence standard. I mean, the Corps knew about this and how bad it was for decades, because the Corps was maintenance dredging the bottom of MRGO because the shoreline, when the ships would go through, would slough into the center. And so you had this constant widening of the channel due to the wakes from these large ocean-going ships that would cause the sediment to fall into the middle, and then the Corps would dig it up, and what would they do? They would haul it out and dump it out into the open ocean where it would be of no use. But obviously the Corps knew for a long time that their project was getting deeper and wider and becoming more of a disaster to the wetlands just because of that, let alone the flooding issue. So anyway.
Thanks. And Dan, I'll get back. I want to go through a little bit on what the court said. And the court said the Corps' failure to warn Congress and provide a mechanism to rectify the problem by prioritizing funding. Government's all about prioritizing funding, whether it's the state level, or the federal level, or even the local level. But importantly, at the federal level, you know, they have the means to tax and to prioritize funding. And in this case, they didn't warn Congress. So the whole point is you want your elected representatives to at least have some visibility of when you're doing something maybe off the reservation. You're going to change what God has intended and put a canal straight out to the Gulf for maybe good purposes. There was military purposes there as well, and maybe some shipping purposes, but you better totally account for the cost and the danger of doing so. And so that's one of the things that the court picked up on, is there wasn't even a warning or any notice to Congress that this was happening. So you had a bureaucracy operating by itself, causing what ultimately led to one of the largest catastrophes. Really wasn't, as of course it wasn't a natural disaster, it was a man-made disaster that nature kind of called us out on. So what did the court say that the U.S. Army Corps of Engineers failed to do? First, they said you didn't even do any scientific modeling. The basic rudimentary scientific modeling that you would have learned in third or fourth year engineering class, whether there was going to be a funnel effect created by the Mississippi River Gulf outlet. They just came to the conclusion, as the law students know, you can't just go straight to the conclusion, you got to show your analysis, but they just made the conclusion there's not going to be an additional surge created by the Mr. Go funnel. There was no critical testing, there was no outside testing. They didn't even ask for any peer review as to whether their assumptions were correct. There was no mathematical modeling that's, you know, these days you can go on, you could probably go online and find some basic models that would have shown a good scientist or a good engineer what was going to happen if we had a surge and how that water was going to affect this part of the state. So the negligence or the fault of the Corps of Engineers, they negligently maintained it, they let the canal widen, they would dredge it deeper, all creating even a greater amount of water that could then come up to the New Orleans area, acted as a funnel. It raised the surges, both the height and the velocity, and Judge Duvall said inundation of St. Bernard Parish in the lower Ninth Ward, frankly, it pushed water all the way through like Pontchartrain to the North Shore. So it had more effect even than what it was given credit for by Judge Duvall. So, is the Corps immune or not under FITCA or the DFE? Deanne.
Thanks, Rock. So as Judge Duvall explained, there was a split in the circuit, and the issue was, would U.S. versus Gobert be the controlling case, or would India towing, a 1955 case that said the DFE exception does not apply in public safety cases. His holding was that Indian towing governed and that the Corps was responsible. The most interesting part of this case is what happens at the appellate level. First panel is made up of 3 judges, Judge Smith, Judge Prado, and Judge Elrod. Basically, they praise Judge Duvall very, very generously. They say that he has complete command of very complicated facts, that he's very judiciously applied the law. It's a brilliant case. They make one small tweak that the federal, the FCA, the wording was a little bit different. Everything else they found, and they affirmed Judge Duvall's rulings.
Deanne, I want to stop you because many don't know your research into this case from the very beginning, and in particular interviewing Judge Duvall. So if you don't mind, take a step back and let the audience know some of the things you did in terms of the ground truthing for your article.
It's not all that exciting. The reason that I left academia to go into being a litigator was because I did interviews, 270 interviews of African Americans, largely from across the city, especially the lower Ninth Ward, as they were scattered in cities all across the country, particularly in the South. And so I saw firsthand what this cost emotionally, physically, the family, cost to the families of these people, and it wasn't just an academic exercise. But being a historian is like being a Monday morning quarterback, really. It's not that interesting, no one listens to you, and we rarely get it right. So I thought that going to law school would allow me to litigate and have a little bit more of a chance. What Rock is referring to is while I was a law clerk...
Thank God you didn't call me a boss.
While I was a law clerk and a student, Judge Duvall very graciously allowed me to interview him, and it was right after he'd made the decision. It was right after the second panel's reversal came back, and I was very impressed because I worked at the CDC, and I have noticed that not all judges are, committed to a heavy docket and lots of heavy lifting with trials, and he had multiple opportunities to get rid of the case, and he didn't. He chose to embrace it. He chose to go through all of the documents very carefully and allow the trial, which is unusual in a FITCA case. And he said, he's from Homer. His work ethic, his commitment to the country. You go inside his office and there are pictures of his family and Marines, and that was their service, right? His service was being a judge. And so he did what he thought was the right thing to do, and being a federal judge, he really didn't have to worry about re-election.
And interestingly, we're already at the first appellate panel slide. Interestingly, the government did not appeal the facts,
right.
Is my recollection.
That's correct.
So typically, the guy who loses is going to quarrel with some of the fact-finding. The fact-finding, that they couldn't dispute any of the facts, that they failed to do the most basic analysis, they didn't do any modeling. All the things that Judge Duvall found as facts, they did not quarrel with at all. They simply they thought they should get out of jail free, so to speak, based upon the government's policy analysis being a exception.
Right. So what they did instead was they appealed the decision, but they wanted an en banc hearing of all of the judges. And at least Judge Duvall's opinion from his moles over at the Fifth Circuit was that the same panel of 3 decided to spare themselves the embarrassment of reversal, and they changed their opinion. But it's a striking reversal because there's no real explanation or justification, either legally or fact-based, for the 180-degree reversal. The second opinion takes out 4 or 5 paragraphs and replaces it with 3 sentences that basically say they could have been policy reasons, and they completely disregard this public safety issues. And again, susceptible to policy analysis comes from Gobert, and it now applies to all public safety cases in the Fifth Circuit catchment. So it's not just Army Corps of Engineer cases, it's not just levy cases, it's all public safety cases.
That's the danger of it, the fact that it's any public safety case, meaning that if it's against the military decides to have an experiment somewhere, and causes, harm, whether it's I'll use the underground nuclear testing or storage of some hazardous material, this could apply to any one of those type of events, although there are some exceptions that are important for those, and being able to get to those. But it's a wide-ranging. In New Orleans, we think about the Corps and government is protecting us from getting wet or worse, but the rest of the country has the same problem in a number of ways.
Okay. So whether or not we're safer is not something we really have to think about in the abstract. We can look at the California experiment, which has taken a very different path. And if you want more information on this, you could check out the Law Review article. But just to sum it up quickly, Paterno versus State, the court decided that the costs of the levee failure were part of the deferred costs of the project, and it wasn't fair to the individual landowners whose home was wiped out by this scientific malpractice to have to bear the burden. And so it was spread out across all the taxpayers of the state of California.
Go back one slide if you don't mind. I want to, these are the policy questions that are up here. As far as, is this what we want? Should we allow judges to invent these possible policy reasons that may not have been considered at all? This is an after-the-fact analysis that says, well, they could have been thinking of this, they could have been without any evidence of that, and that gets them off the hook. So, is that a good thing? If you're a Tea Partier, that may be a good thing because you don't want to have to pay for government's mistakes. But somebody has to pay, and it shouldn't be, as Deanne said when she went and interviewed these hundreds of people and saw the emotional toll that it has. That emotional toll rarely gets put in that learned hands calculus or algebra. So, it should be, you should have to show your math. You should have to show your work. It should be long division analysis if you're going to do it after the fact. You shouldn't be able to be as a judge saying, well, they may have been thinking of this or thinking of that, and we're going to get them off the hook because they have a whole lot to think about, and they make tough decisions. They're the government. Nobody else is building levees, and we're going to give them a pass if they get it wrong on occasion because they're doing the work that keeps New Orleans where it is. So that's the question: is whether we want to make them show their long division, make them show their math, and if they do it wrong, hold them accountable. That way, the taxpayers as a whole can say, maybe we need to have a better U.S. Army Corps of Engineers. Maybe we need to we need to increase the salaries of the engineers. Maybe we need to have more of them. Maybe they need to do something different. But if you don't do that, it does not give the government any incentive to get it right. And that's the danger of having these judicial traps or fictions.
Thank you. And I'd also add to that the second policy consideration is whether a government agency should be exonerated or should be blanketed with immunity if they had the ability to warn in advance both the government, Congress, who had the authority to give more money to fix the problems, and the communities in harm's way. Because as Rock said earlier today, he said, if the communities had been forewarned, they could have lobbied the legislature themselves. They could have put pressure on them for different funding priorities. My position has always been that at least people would have had the choice how they were going to spend the money that they had, however little it was. Were they going to keep investing in the community of their grandfathers and their great-grandfathers, or were they going to choose to move and start a different life, but on terms of their own, not at the last minute, packing for a weekend to never have your life the same again?
This next slide is important. To test whether that would work, Dan found that California did an experiment to see if they could build in the cost.
The best part about the California experiment is that it puts pressure on the politicians, because politicians are looking at the next re-election, and there's nothing sexy or exciting about investing money in infrastructure. It just doesn't sell. It's not what your constituency wants, right? And so if you have to then raise taxes to pay for the damage award of $500 million because of one levy that failed, that wiped out one family's property, you have a whole different equation, and you can be voted out of office for that.
So take them through. I mean, they did.
Dustin's time.
Oh, we got plenty of
If
time.
you want to,
Oh, you're right. Go ahead. Go ahead. Keep it. Yeah.
yeah. Okay, so again, Paterno, you can look at the article. It is long, but Paterno's section is short. All right. There are fiscal considerations, like the problem, at least with the Army Corps case, is that the money judgment would not have come out of the Army Corps' budget, so it would have been shifted to the American taxpayers as a whole. The way around that is the argument that taxpayers are actually like shareholders, and so if they have not incentivized their politicians to do the right thing, then they should be found guilty. They have a moral obligation to pay. And we have to look at the consequences of these ever lower taxes on communities like, well, all of the Orleans Parish neighborhoods, and all the coastal communities in particular. So lastly, I propose that there should be a new test for the next case that goes up that could sort of save Indian towing and do away with Gobert, at least in connection with the public safety cases. So first, I would propose a hard look deference test, very much like the administrative law test. So it's not, the judge's job is not to analyze whether the policy analysis was good or whether the judge in hindsight would have made a different choice. But if you at least can prove that you did make some kind of a good faith policy analysis, then you could qualify for immunity. But there are two other components I would add to that test. The first is, if the agency had the possibility of reporting to Congress and prioritizing its budget requests, to qualify for immunity, they would have had to bring the problems to Congress's attention and make those requests accordingly. And thirdly, this test is irregardless of whether or not they have the right to report to Congress. Did they bring to the private citizens in harm's way news of the damage that they had and the risks that they faced? Otherwise, immunity would not apply. Thank you.
Bessie's going to talk about another fiction, the subsequent purchaser doctrine. It comes up in land contamination cases more often than not. It's when if I buy a piece of property, say I bought a farm, or even I bought a small little 1 acres, got a little tomato, plant some tomatoes and go to water them one day and they just die, and I realize that I taste the water and it's salty, and I realize that there's a saltwater disposal well that's leaking across the street or on my property, and I go to sue for that. There is now case law, unfortunately, that says I don't have a right except to the person who I bought the property from for that damage, and sometimes those damages can exceed the value of the property by 100-fold. So unfortunately, that makes, if this subsequent purchase doctrine keeps going, it will allow this state to be a dumping ground. But Bessie will talk about that. Thanks, Bessie.
A lot of familiar faces. Some people I got to say hi to before, others let's visit after. So yeah, the subsequent purchaser doctrine, a little more context. Most of the casework that Rock and Deanne and I do is representing landowners for oil and gas contamination. And that's on property that has been explored for oil and gas for many, many, many decades. And so over the course of those decades, sometimes you have the same landowner has owned that property for generations, but oftentimes it passes hands. And so the question arises, a landowner comes to you, that landowner has determined that there may or may not be oil and gas contamination on their property. What can they do about it? How far back can they reach for claims to seek cleanup of that contamination? The subsequent purchaser doctrine itself really goes all the way back to a case that had nothing to do with oil and gas, an 1851 case called Clark versus Warner, decided by the Supreme Court, Louisiana Supreme Court. In that case, a neighbor brought a suit for damages caused by an ice house on neighboring property. And the court made a couple of findings, and its holding concluded that a purchaser is presumed to purchase all actions appurtenant to the property, including anything that goes along with full enjoyment of that property, but said specifically that you don't get the personal right to sue for pre-purchase damages, and concluded that the reparation really belongs to him who suffered it. And so this question arises of who is the him, who's suffering it. The court looked at the idea that the purchaser had bought the property for a fairly moderate price, kind of looked at that's probably what went into the apparent damages is probably what went into that moderate price, and then left the reader with the idea that you really can't get a windfall for these damages that you knew about. It looked like it was going to be a profit source for the new landowner, and that felt wrong to the Clark Court in 1851. Skipping ahead is a decision called Prados versus South Central Bell in 1975. And in that case, the court really refined this concept. In that case, there was structures on a property that had been put on the property by a former lessee, and the new owner wanted that former lessee to remove those structures, and the former lessee refused. So the new owner brought an action for breach of the obligation to restore against that former lessee, and the court concluded no way, no how. The purchaser has no right, the seller's personal rights to pursue that claim against the former lessee, pursue that restoration claim against the former lessee. They didn't transfer in the sale, they weren't accessory to the sale. Now, importantly, the subsequent purchaser doctrine dating back to 1851, Prados, for like 40 years, it was clear that it only applied to apparent damages. There wasn't any question of whether it could apply to unapparent damages. For example, contamination, subsurface contamination that is not visible, that you don't see until the tomato plants start to wilt from salt. So that proceeded for 40 years until the landmark case of Eagle Pipe, which was in many ways a death knell for claims for landowners because it extended the subsequent purchaser doctrine to unapparent damages. A little more information on Eagle Pipe. The plaintiff had purchased the property from former owners who actually leased the property to a pipeline cleaning company. And so then this new owner has the property, and the LDEQ comes out and finds out that the property is just riddled with norm and other radioactive components, and goes after the Eagle Pipe company for cleanup, for remediation of that norm. So Eagle Pipe turns around and tries to bring this claim back against the actual pipeline company that deposited the norm on the property. And the court goes through a very extensive review, going all the way back to Clark and Prados and a lot of other cases that I'm not going to spend time on today, and looks at the subsequent purchaser doctrine and concludes that the foundation and the evolution of the case law is sufficient to apply it to unapparent damages. So the radioactive material was not apparent, but at the end of the day, Eagle Pipe, the new landowner, has no claim for those unapparent damages. Interestingly, the court noted that as an owner, you buy a piece of damaged property, you have a claim for rescission against the former owner or reduction of the purchase price. And the court seemed to suggest that there was some equity there in that you can go back against that former owner. And so it's that former owner who really has damage in one of two ways. If the damage is apparent at the time that it sells the property, then they have to sell it for less of a price. So they sustain damages in a reduction of the purchase price. If the damage is unapparent at the time that that prior owner transfers the property, then the new owner has a claim for rescission, and so again, you go back to that former owner who has this damages because he or she may have to defend against a rescission claim. So there was something in the opinion that suggested that there was equity in leaving the right of action with the former owner, but as I'm going to kind of explain to you, at least in the oil and gas context, it doesn't work out that way at all. A couple of notes on the case that a colleague of actually Rock's partner, Mike Viron, shared with me yesterday that are worth pointing out. This subsequent purchaser doctrine has actually never been adopted by a majority of the Louisiana Supreme Court. There was no majority opinion in Eagle Pipe. It was signed by only 3 judges. There were a total of 8 opinions on the case, which is no small feat for a 7-member court. Importantly, while it's had such extensive play in the oil and gas context, I mean, I think we see it in just about every case we have now, unless you've got generations of ownership. It was not an oil and gas case. It was a lease case. That it had nothing to do with oil and gas operations. And since Eagle Pipe, the courts of appeals are all over the place. I've heard someone describe it recently in some writings that we have descended into chaos post Eagle Pipe, trying to figure out really which way is up and where do rights stand. So that takes us through the history of Eagle Pipe. What did I do with the thing? Here it is. Does this work? There we are. All right. So we've got all the way through now this seminal case, Eagle Pipe. Where does that leave us? The real crux of all this case law is the question of what are personal rights versus what are real rights. The premise now of this so-called doctrine is that the right to sue for damages to property is a personal right that does not run with the land and that must be expressly transferred to a purchaser of the land. Just to pause there, for those of you who've already had property, there's always this question of real rights that run with the land. So at the core of the subsequent purchaser doctrine is that we're talking about personal rights that belong to the prior owner that do not run with the land, that are not real rights, at least as this is being played out in the case law. The effect, again, is that a purchaser is limited to pursuing damages that occurred subsequent to her acquisition of the property, and most importantly, that is true whether the damages are apparent or not. Now, let's get to the meat of the matter. If I could make this thing work. There we go. Is what are the fictions that we're left with? These are the existing fictions, 2 really of many, but these are 2 that I think are most pronounced. Is that number 1, the fiction is that a purchaser knows the full condition of the property, that the purchaser takes that condition into account in agreeing to a sales price, and that if you were to allow, as a court, if you were to allow the purchaser to pursue claims for the damages that occurred prior to acquisition, that would result in a windfall. In the cases that we're involved in, the landowner buys some property. There may be oil and gas exploration on that property. They may be hoping to have the benefit of the royalties from the exploration on that property. But in no way, in our cases, are landowners fully apprised of the depth and the degree of the contamination on their property. There may be some salt scarring, but you may not know until many years later, and you get experts involved, whether you've got groundwater contamination or such extensive contamination that you really do need to look back to maybe the heaviest period of exploration that happened on that property.
Which may be 30, 40 years earlier.
Right. You may be getting little tiny royalty checks from a small operator who's doing a little bit of exploration when one of the big boys was there decades ago, really working that property. And going far beyond what is permissible in terms of depositing of waste.
And the problem, as Bessie may have alluded to, is that the cost of cleaning up the property is sometimes in the tens of millions of dollars, and the value of the property may be, 1/100th of that, if that. Now, luckily in Louisiana, we have a case called Roman Catholic Church that says you do not tie the cost of remediation to the value of the property. If that was the case, then, you can imagine no one would have an incentive to clean up, because all they'd have to worry about is going to pay, $10,000 for an acre that would be done with, regardless of whether there was $2 million worth of norm to needed to be cleaned up on it. They wouldn't clean up the norm, they'd buy it for $10,000, and that would be the end of the story. That'd be the most of the damage. So that's the real problem we have, is we only have so much land in Louisiana. We're not making any more. We're losing it, in fact. And if this policy takes hold, we know that economics, land is going to get transferred. And so if you're a corporation, you wait it out. Eventually it's going to get transferred, and I can invoke the subsequent purchaser doctrine and not have to pay a thing. That's between the current landowner and the one that sold it to them. And it inevitably turns Louisiana into a potential dumping ground because there's no incentive to clean up.
That's absolutely right, Rock. And the other interesting piece on that is the economics of dumping these contaminants onto the property is that if you can transfer it and you can leave that between the prior owner and the current landowner, then operators basically get free storage of an enormous amount of waste without having to factor that into their budgets, and that just seems inequitable, and that's completely aside from the environmental interests that I know we and probably most of the people in this room are focused on. The other fiction that the currently existing with the subsequent purchaser doctrine is that you can even break apart the pre and the post acquisition contamination, that it can be unmingled such that a purchaser can demonstrate which particles of contamination occurred before or after the acquisition. I mean, think about it. You've got a flow line or a saltwater disposal well that's been leaking slowly for decades. You kind of roughly know going into the operation documents when it started. You may know when it stopped because there may be an AFE that indicates that money was spent to fix it. There's no evidence in the records after that. But we're talking about, in these cases, 40, 50, 60 years of records trying to piece together when the contamination started, how long it lasted, and then it's just there. We're sending out experts today in real time to identify where is the contamination, where's the salt, where's the arsenic, where's the barium, where is all this stuff on the property. How can you tell which particles were deposited because of a flow line that leaked when I bought the property, or a flow line that was leaking when Rock had the property before he transferred it to me? So that's a real challenge for landowners as plaintiffs in these cases, and for the experts that they retain. So this is these are just two of the fictions that the subsequent purchaser doctrine today, I think, promote. But we also have some open questions on the future of the subsequent purchaser doctrine that I'd like to walk you guys through, and the risk of some additional fictions that are going to continue to chip away at land rights. Before I get down from here, I'm going to learn how to work this thing. Oh, there we go. It worked. It worked. Just pointed at you guys. So Eagle Pipe itself said that it expressed no opinion as to the applicability of its holding to fact situations involving mineral leases or obligations arising under the Mineral Code. Applying the subsequent purchaser doctrine in either of those contexts, where there's a mineral lease in effect or to mineral servitude obligations, it's our position that that promotes two additional fictions. Number one, that the express or implied obligations owed under leases can be mooted just by transferring the property. There's a lease in effect, but if you just shove that property over to somebody else, the lease sort of becomes enforceable, and the code articles sort of becomes enforceable, but not all the way. And the other is that end-of-lease obligations under Civil Code Article 2638 to restore the property, and the obligation to restore owed under the Mineral Code 3122 the fiction is that those are even divisible. So I'm going to walk you through that a little bit. As to the lease in effect, it's important to know that no case, not a single one of them, don't let anybody tell you differently, not a single case has ever applied the subsequent purchaser doctrine where there is a lease in effect at the time of acquisition by the landowner plaintiff. Eagle Pipe did not involve a lease. It had terminated before the Eagle Pipe purchased the property, and Eagle Pipe itself really delved into the fact that there was no existing lease, that it had expired in the case Prados, which Eagle Pipe relied on heavily. And thinking about a lease is going to include some obligations. It might have some restore obligations in it. And then there's the implied lease obligation, as I mentioned under Civil Code Article 2683, that says at the end of the lease, you can use it as a prudent administrator, but at the end of the lease, you have to return it in the condition it was at the time of delivery. So there's one important point that I'll emphasize here, and I'm going to get to divisibility in a minute, but think about that. You've got a lease. As I said, the lease has been transferred with the property. There are rights expressed in the lease. There are rights expressed in the Civil Code. And the subsequent purchaser doctrine, we're at risk of it being extended to hedge those obligations so that you're only responsible for those obligations insofar as you've owned the property, not insofar as those obligations have existed on the property. And interestingly, when you think about end-of-lease obligations, what if the lease terminates when you get the property? It's suddenly over. You're the first person who's been in a position to even enforce those obligations because they weren't enforceable until the lease ended anyway. So it's extremely problematic and for landowners and for lease obligations as we understand them and respect them in Louisiana in the first place.
That's your question.
Oh, I'm sorry. Go ahead.
I just had a question. Is there another way to think about it in the sense that what we're talking about when we talk about Eagle Pipe are personal rights in tort, and what we're talking about, I think, when we're talking about mineral lease rights are real rights that run with the property?
Yes, that argument has been made, but the argument that's being made right now in cases that we're in is that even if you have a mineral lease in effect, and that mineral lease is in effect at the time that the landowner purchased the property, there's operators, defendants are still making the argument that you can't collect for damages even under contract prior to acquisition.
Personal rights versus real rights is what it's all about. You can go to about 3 code articles in the Civil Code and look at the comments that your Professor Yiannopoulos has on those, and he makes it real clear that real rights run with the land, and when you're able to make that argument, you can tell in which cases I won those issues. When you're able to make it to a judge that understands those concepts and reads Professor Yiannopoulos' comments, they get it right, in my opinion. And when they don't take the time to read that and really look at the difference, as you mentioned, the difference between personal rights and real rights, in that real rights, property rights run with the property regardless of how many times it gets transferred. And that's good policy, because if you don't, why should how much a property gets transferred, capitalism, economics, have anything to do with what that property right has in terms of getting cleaned up? Just take out everything else you want to. It's just not good policy that a simple transfer is going to mean that a piece of property escapes, allows somebody to get out of jail free and not clean it up. So it's all about that, personal rights versus real rights. So if you're taking property right now, go back. I wish I would have paid a little bit more attention, because that's what it's all about.
Any other questions? Let me add this. Oh, I'm sorry.
I just want to make one more quick point, because I know we're running out of time, and it really does segue into what we were just talking about here, is this concept of real rights. Under Louisiana Revised Statute 3122, a mineral servitude owner has an obligation to restore the property to the original condition at the earliest reasonable time. There is no question that is a real obligation that should run with the land. There's a case called St. Jude that analogizing to that provision, said that restoring the premises to a previous condition is a real right that follows the immovable. Eagle Pipe itself said that a servitude being a real right follows the property without the necessity of inclusion in active sale, unlike a personal right, and the new owner has the right to enforce that obligation. And recently, a case that Rock and his partners were involved in, AgriSouth versus Exxon, and I think we confirmed that writs have been denied. The trial court in 2015 said very clearly the subsequent purchaser doctrine does not apply to mineral servitudes, and went so far as to say that to hold otherwise would render Article 22 meaningless. And there's a lot in that, and this is the last thing I'll say, that goes to both that restore obligation under 3122, also that restore obligation that I mentioned under Civil Code Article 2683, those restoration obligations. If you go back and you look at the code articles, the Civil Code articles on indivisible versus divisible obligations, they apply so tightly here. You cannot, how do you partially restore something? There's a great case called Sweet Lake that really went into this concept of you can't partially plug a well. You're either in all the way or not, and it makes no sense to take the position in case law in Louisiana that these restoration obligations that are owed completely can be owed partially. So with that, I'll turn it over to you, Bill, for more questions.
Any questions? Okay, let me throw in a few comments on some of this. We'll Eagle Pipe first, right of action, and then I comment on the sovereign immunity issue. Essentially, this no right of action rule that has been developed through, I'll give credit, excellent defense lawyering. Okay, excellent defense lawyering to take, as Professor Maury used to say, make chicken salad out of chicken bones, okay? But they take this old rule that clearly shouldn't apply to this. Nonetheless, basically it says, you as a landowner don't have standing as a landowner to get your property cleaned up. That's what that rule is. It's totally contradictory to what my concept of private ownership in this country is, land. All right? But I will submit to you that what the good Lord taketh away, the good Lord giveth. And as a member of the general public, as an owner of a land that is subject to environmental damage and environmental threat, you do have standing under the environmental statutes. And a citizen suit to address those would not at all be affected by this Eagle Pipe rule. So if you're in a situation where you're litigating private damages for a landowner and the court tells you, oh, I don't have standing for this, send your citizen suit notice out and get after it, okay? Overcomes prescription as well. All right? Now, with regard to the discretionary function, one other comment, and then maybe there'll be some more questions, I hope. Whether or not government should be accountable and the shifting of money back and forth, that's all. That is what it is. But I'll submit to you that the other thing that needs to be considered is what a trial does besides allocate or take money out of somebody's pocketbook. It exposes them. It shames them. It lets the public know through fact and law and evidentiary rules what really happened. And there may be faults within that system, but that is the rock foundation of our government and our legal system. And having these legal fictions that take away the right to have a trial and put on evidence and make decisions about what really happened is a serious problem that people need to think about before they start waving out these defenses to achieve an immediate benefit in a very, very narrow, specific situation. MRGO has been dam, okay? They've got sills in it now to protect that storm surge. There are other things that are happening to MRGO, other Navigational Corps of Engineers projects, in Louisiana. And I'll submit to you that a trial like that went down in the MRGO had an effect on that agency and the government's decision to address a problem that probably would not have come about without that trial.
Actually, on that point, I have a question. Couldn't you fashion a statute more like NEPA, where you're obliged to do these risk assessment things in advance of government action, and then people could challenge in advance rather on the validity of the decision, rather than having a damages regime afterwards? I think that might be more palatable.
It's a good idea. I don't think we always know in advance what the damage is going to be. And one of the big problems with the Army Corps' modeling is that they didn't follow the damage over 20 or 30 years and keep up with and track it and report it to Congress. So you'd have to have both mechanisms.
Right, for a continuing duty to update.
Right, exactly.
Good point, though.
Yes, excellent.
Yes, ma'am.
Have there been any recent NEPA compliance by the court on any updates or rejiggering of that project? Because some of that would have to be analyzed even in a small EA. But it may have been that it just sat there for years.
It should be, and that's what, comment periods in rulemaking should bring about, the ability to have these discussions through a comment period and rulemaking, and when they do these things, in that way the public has a right to come in and check their math as each step.
The court has a huge NEPA establishment.
True. Well, one of the things brought to mind when Bill was talking about the great things about a trial, bringing things out in the open. Going back to this slide, the point is the discretionary function exception means that 75% of the time the case gets dismissed without ever seeing the inside of the courtroom.
Or discovery.
Or even discovery, exactly. These are one of the first exceptions that get brought out. Sometimes before discovery, before you know anything, the government shows its badge and says DFE, and court says, just without even sometimes as an oral argument, you get thrown out. So there's hundreds and thousands of cases, literally, that do not make it to court because of the discretionary function exception, and that's too bad, because we don't even get to the point of discovery where things can be pointed out that were done improperly. Any other questions?
Well, the high-profile Southeast Louisiana levy board lawsuit. Perspective on that based on what we heard today.
Wow.
That's another hour.
We got 30 seconds. Bessie and I can say that when we filed that lawsuit, one, we never imagined that the Governor General would be on Koch brothers' property when that happened, and the Koch brothers obviously had defendants in the case and an interest in it. We didn't expect the immediate backlash. We, of course, expected when you go about doing what we did to have some controversy. But the plus side of that, in bringing out all the things that we did to show the public what all this dredging of the canals did to our coast and made it, basically allow the saltwater intrusion to occur and let our coast die. That allowed for the public, and what we didn't expect is the press to follow it and report it as well as they did, and to expose what we found through our due diligence before we filed the lawsuit of exactly what was happening, what they ignored, why they did it, that they took the money, they got the benefit of it, but they failed to do what they were supposed to do and simply fix what they dredged, or in the case of pipelines, monitor those things and make sure that it was fixed. So we never expected that, and hopefully that year of us trying to get it seemed like being killed every day allowed the public to raise that level of discussion, that everyone understood what was going on, because it is important. And we'll know we do have oral arguments in the U.S. Fifth Circuit on Leap Day, February 29th, and we'll see what happens. But that's another seminar.
I would just add, the second half of my article talks about the legal arguments and how they would apply to that case. So if you want to look.
Sort of relatedly, the parish cases that were brought for coastal management enforcement. We saw the last few months Plaquemines dropped out, but then a couple weeks ago Cameron got in. How important, Jeff compared to this beginning, how important is it to have, in your opinion, multiple parishes there if there's going to be any kind of administrative arrangement or global settlement down the line?
It's too early to tell. It's a great question. It comes up all the time. You could take the 10,000-foot approach, is that this should be really done on a state level because it's hard to do this block by block or parish by parish. But it does make it where perhaps the oil companies are having to fight wars on maybe 14 different fronts, which is not good for them. So there's no right answer there, but those are the two sides of that. Yes, ma'am.
Yeah. Was this principle evident in the legacy lawsuits?
Which principle?
The principles that we were discussing in the legacy lawsuits that the property owners had brought?
The subsequent purchaser?
Yeah.
No, it's in every one of them. The first thing out of the blocks we get is a exception of no right of action. And
It's new, it wasn't the bill.
so it wasn't, and is it new? It's a 18-month, 2 years, it feels like we've been having to deal with that.
Feels like a lifetime.
Feels like a lifetime.
2 years.
Yeah. Some judges get it right, some get it wrong, and that's why the circuits are split, and we'll see. The Supreme Court has not taken it up and heard it on a typical legacy lawsuit yet.
Okay. Right.
Thank you all. I think we'll...
Got another question. Well, comment to the question. I've worked on sovereign immunity cases a bit. It seems to me the real problem with the discretionary function exceptions is there are very few, if any, important government actions that cannot be described on the one hand as negligent or whatever, carried out of a decision already made. That's your so-called ministerial action for which the government is liable. Or as a result of a policy choice, which is what the discretionary function exception is supposed to protect. Was it the planning decision to build Mr. Go that caused the problem, or was it how Mr. Go was built? Well, the answer, of course, is it's both, which gives the court discretion, if you will, to choose which way to go.
And we don't like that. We like to be able to know, we should know what the rules are going in. And with what you just articulated is absolutely true. We may not know at any time whether the judge is going to give them the free pass or not, and that's unfortunate and needs to be corrected. And hopefully the ANS test will get traction.
Everybody, thanks. Go see Vicki. Go see Vicki. CLE, sign up over here.